Hey everybody, it's Reggie with Lawyer Interviews. Today we have the honor of talking with Daniel Martinez, who is a criminal defense attorney out of Palm Bay, Florida. Daniel is going to tell us everything criminal and defense, and as well as show us an amazing tour of his boxing studio connected to his firm. How cool is that? Today's Lawyer Interviews is being sponsored by the team at Litigation and Select America's Legal Elite in Media. Hey everybody, it's Reggie with Lawyer Interviews, and today we have the honor of having Daniel Martinez out of Florida joining us today. Hi Daniel, how are you?
Hello, how are you today?
Good, good. Now Daniel, you practice a number of areas of law, but as we just discussed, your probably bread and butter is criminal defense, correct?
That's absolutely right. I'm very heavily involved in litigating criminal cases.
Very cool. And how long have you been practicing?
Since 2015.
2015. All right. Very cool. Now, Daniel, we were just discussing that you've had some really interesting criminal cases on the spectrum, including some capital murder cases. And I think our viewers would really love to hear a little bit about what it's like being an attorney representing someone charged with capital murder.
Sure.
How did that case come up for you?
Well, I've had quite a few capital murder cases, whether it's at the trial court level where I'm representing them through the initial prosecution following an indictment, but I also have quite a few that are appeals where it's after a person's been convicted. But so there's a different approach to that, and there's a different way you develop those cases. But I could tell you from the standpoint of doing a criminal case, a capital murder case is totally different from any other type of case because, of course, the stakes could not be higher, Reggie.
Right.
And
right.
essentially, you have to think, even where a case is completely unwinnable in your mind, you have to think of creating a record. And this means that you have to file every motion under the sun. You have to hire every expert witness under the sun. You cannot leave any stones unturned because, again, not only are the stakes so high, but 100% of capital murder cases where a person is convicted end up in the appellate courts. You don't find very often that someone will appeal a DUI or a misdemeanor case. So having a spotless record is not as important.
Right. Now, when you are, taking a capital murder case, are these ever assigned? Do people reach out to you to represent them? How does that usually work in your practice?
Well, there are some attorneys that are, there's obviously public defenders, and when there's a conflict out of the public defender's office, which for those people out there that may not know, for example, as attorneys, and you know this, Reggie, if there's a conflict of interest, I can't represent a defendant where a witness in that case testifying against my my client, my prospective client, was one of my previous clients. Because I as an attorney, I'm armed with perhaps secret information or damaging information, if you will, and I can use it against them. So you could never have a conflict of interest. For that reason, they assign private attorneys such as myself some cases out of that normally would be public defender cases if they are indigent. I'm not one of those attorneys. I am a 100% private attorney. I have my own firm, and people would have to hire me. And the price would depend on the circumstances, numerous circumstances. But so they would call me, they would hear about me. I get a lot of clients through word of mouth. I'd like to say, and I'd like to believe that I zealously represent my clients, and I get the results that has them reaching out to other people and putting my name out there.
Absolutely. And criminal law is so interesting. I told you before, we began the interview, I believe that criminal attorneys, especially on the defense side, are protectors of the Constitution. And that is because, you are really defending someone's, literal rights of freedom, and, their freedom is about to be taken away, potentially, given the charges. But, on the balance, on the flip side, I know that some of these charges are egregious. Probably some of the facts and evidence are also heinous.
Naturally.
How do you handle that? Personally and professionally.
That's a fair question. And I too firmly believe that every person is entitled to a defense. And the way that we have to compartmentalize this, in my opinion, is you can't think of it on a case by case basis. Either we all have rights or none of us have rights. Right. So what I mean by that is that when I represent somebody who has egregious facts against them, I think, well, this isn't just for this client. This is so that the next person who truly is innocent has the liberties and has the shield of the Constitution, if you will, and their rights being actively litigated. It's not just in other words, our laws are not just theoretical when I get involved. It's practically applying them to a case.
Right. And like you said, too, protecting, making sure evidence is in there for viewers who may not know. If you don't bring something up a lot of times in, the lower portions of the court, you don't preserve those objections later or preserve that evidence to be brought up later, because appeals courts really look at the lower court's record. And so it is so interesting. I mean, there's so many even crime documentaries out there that talk about how it's like, well, they didn't bring it up in the lower court, so we can't hear it here.
Absolutely.
What's your opinion of that when you see those kinds of cases?
Well, and that's why what I said earlier applies with the capital murder cases or homicides, because you're absolutely right. If something is not preserved at the lower level, and how is it preserved? There has to be an objection, a timely objection. So if the state of Florida or the state is bringing in evidence and I wish to challenge that, I have to object immediately, contemporaneously, to preserve that objection so that later the appellate court can look at that issue. If I did not object, and if I did not object timely or appropriately, then that objection would be forever waived. And that's why it's so incredibly important to have a competent trial counsel.
Right. Absolutely. Absolutely. I'm sure another, I guess, hurdle in a capital murder, incident would be, how do you communicate with a client who is, being held for capital murder? How do you have these interviews? How do you prepare for a case like that?
Well, one of the, as sad as it was for our country and for the world, having the pandemic, it has created a lot of opportunities by way of technology. We're experiencing that right now by having a Zoom interview, right?
Right.
And so now we're in this new era. So I'm fortunate that my particular jurisdiction that I handle the most, I'm not just in my area, but where I primarily practice, there is a system where I can set private video appointments that are not subject to review with my clients. I can email them through that system as well. That's all private. I can send them documents. I can send them photographs, and we can communicate in that way. So that's
and that's not monitored by the government.
Allegedly.
Allegedly. Yeah, we always allegedly. Yes, of course.
That's one of my favorite words. But no, I mean, it says it right there. And quite frankly, I mean, anytime the attorney-client privilege is so powerful that I believe in my heart that even if I was being surreptitiously or illegally recorded talking to a client, they couldn't use that anyway.
Right.
But in this case, they're asserting in no uncertain terms that they are not subject to monitoring if you're an attorney and if you use your bar card and application to get part of that system.
Okay, so you as the attorney have to apply and then be able to let the inmate be able to communicate with you. And can they do that with anyone else, or is it like family, or is it really just a communication for you?
They can talk to family and set appointments with family as well, but they're not protected communications. In fact, if you like stories, I had a client who he was in jail and he was having a video visit with his brother, but then I believe the inmate was either showing the laptop, because it's like a little iPad that they give them. So either the inmate was passing it around and to other people, hey, what's up, man? How you doing? Or it was either that, I can't remember exactly. It was either that or he was, oh no, I know what it was. His sister had recently had a baby and she was holding up the baby to the camera. And so that apparently was frowned upon, and then he was not permitted to use that system. But they couldn't observe our communications, of course.
Right.
I mean, granted, I'm not going to be holding babies in front of the camera.
I mean, maybe less interesting to the, person involved, but, still very important to communicate with your client.
But it is a good system because, quite frankly, I used to have anxiety about the fact that I couldn't see my clients as often as I wanted because there's a drive to the jail and then you have to wait till they bring them up. And the process of me seeing 3 or 4 inmates would take me 3 or 4 hours.
Wow.
And then that's not including the round trip drive, which would be another hour or so. Whereas now I can see 4 inmates an hour because there are
Right.
15 appointments.
And I'm sure also like the restrictions of what you can bring in and, to be able to help, versus
Yeah.
you've got your computer right here, you can look it up and
Oh yeah.
that's very cool. Now, how long from, take one of your, most recent capital murder cases from beginning to end, what was the time period like?
The process, it candidly takes a long time because again, you have to set every deposition possible. You have to do so many different things.
Mhm.
And so it took 3 years.
Right. Right.
Ultimately, we got, and I can say this, I can't divulge the name of the person, but the case, we were involved in plea negotiations and I filed so many motions to dismiss, motions to suppress, and I made the state work very hard. And I find that when your attorney is aggressive and makes them work hard,
Mhm.
they are more susceptible to coming to a plea agreement that's acceptable for the client and the state. And in this case, my client was charged with second-degree murder, and it was ultimately reduced to voluntary manslaughter.
Wow.
He got 10 years in the Department of Corrections, which sounds like a lot. It is a lot, but he could have done life in prison. He got 10 years. He gets 3 years credit for time served for the time that he spent in jail. So then that leaves him with 7 years left. And you only do about 85% of your sentence on good behavior. So
Right.
I can expect him to ultimately get out with those 7 years that are left, probably out in about 5 years.
Okay.
So to me, that's a win.
Oh yeah,
And
absolutely.
and it's funny, this is kind of like an ADD thought, but I think it's appropriate here, that oftentimes I get asked, Mr. Martinez, what's your win loss rate?
Yeah.
What's your record? And you really can't quantify a record because on one hand, he got convicted of manslaughter,
Right.
felony conviction of a very serious kind. So that's a loss in one hand, but in the other hand, it's a huge win because
Mhm.
he's doing 10 years when he could have done life. So you really can't ask a criminal attorney what their loss rate is and
Right.
expect any reasonable answer because it depends. What's a win to you?
Right.
If I keep you out of jail, that might be enough for you because you, let's say, if you've already been in trouble so many times, well, you're already a convicted felon, so your only concern is not going to prison, right?
Right.
Whereas
Right.
there's other considerations. If you're a first-time offender, that's not good enough. Well, Mr. Martinez, you're keeping me out of jail, but I don't want to be a convicted felon, or
Right.
I don't want to lose my license, or I
Right.
don't. So it really depends on the circumstances what a win or a loss is.
Right. And I think a lot of people don't realize that too, is how much negotiation from day one goes on between not just criminal attorneys, all attorneys, both sides, mitigating the, excessive, and kind of narrowing down to where plea agreements or settlement discussions, come up.
Right.
And I really like something you said earlier. You said you're aggressive, you're an aggressive litigator because you make the other side work hard. And I think that's such a good piece of advice for people. I think a lot of people out in the public, they go, oh, I want the attorney like on the movies that comes in and pounds their fists. And that's not what I think aggressive litigation is, putting the other side up to prove their burden and prove their allegations. And I really like that you say that because I think sometimes they're like, oh, attorneys, they charge a lot, whatever, but there's a lot of work that goes in. Like you just said, motions to dismiss, motions to exclude evidence. I mean, when you're talking about a case like this, how many motions do you think you file?
It depends on the case, but I mean, it could be 40 to 50 motions on a capital murder case.
Right.
It depends, obviously strategic. It depends on, you should never have a blanket policy.
Right.
My policy, because there are some cases where I don't want to do any depositions, where I'm so confident in my strategy at the beginning that I don't want to give the state time to shift gears. So someone might say, Daniel, you're not doing any depositions and you're not filing any motions in this case. No. And I know it, as long as I know why.
Right.
There's a rhyme and a reason behind it. I might want to file a demand for speedy trial, which makes the state have to take them to trial in 60 to 90 days, and they're not going to be ready. And I know that.
Right.
So it really depends on the case. But I find that there are so many attorneys out there that are called pejoratively, plea lawyers.
Right.
So they'll take your money and they'll sell you on a dream of all this stuff that they're going to do. But then when push comes to shove, they're afraid to go to trial.
Right.
Therefore, the client will never get the possible deal, the best possible result. Whereas in my case, I don't wish to sound arrogant, but I am a very, very polished trial attorney. And
Right.
so the state attorney knows that if plea negotiations end with me, I am
Going to trial.
comfortable taking it to the door. Absolutely.
Yeah.
I just got a mistrial. This is a really interesting one for the people out there, where the state attorney, and I really can't say names with this one, but he was found to have committed prosecutorial misconduct in trial. I discovered it. Basically, how can I say this delicately? Because there's ethical considerations, because there's an investigation by the licensing board at this time. But
right.
In the middle of a trial, my client was charged with aggravated battery with a deadly weapon, 2 counts.
Mm-hmm.
And if he was convicted, because he had enhancements, he was what's called PRR, prison releasee reoffender.
Oh, okay.
Habitual felony offender. So that means that there's automatic sentencing enhancements, that if he was found guilty, he would have had to do 30 years day for day, automatically, no 85%, no game time. And the state attorney knows this. They knew the stakes. And despite that, they did some questionable practices in trial trying to prove their case. And in that case, I got a win without even having to go to a jury.
Right.
And
right.
Because I found the misconduct, pointed it to the judge's attention, he ultimately granted a mistrial with prejudice. So they can't even refile him.
Right. Right. And that's the thing is sometimes it's not necessarily a case is not necessarily about the merits, but it's also about the procedure and what the attorneys on the other side do. Or the authorities, the government, the cops, would they follow a chain of evidence? Did they collect a right? Did they Mirandize someone, So there's so many things at play when people, look at a trial, you don't realize the years of development these things take. So I'm sure that you've just seen some real fun things, but I love it. I agree that there are attorneys out there who would barf if they entered a courtroom for real. On a trial.
I saw that yesterday in a case, very serious, a murder case where I'm actually representing the victim's family.
Okay.
Which is really nice to be able to switch gears.
Yeah, absolutely.
In that case, the defense attorney was so extraordinarily aggressive that it bordered on offensiveness, and you lose your audience if you're doing that. You can't be the TV lawyer. I mean, there's a time and a place. And don't get me wrong, if a witness on cross-examination tries to wiggle out of my questions, I'm gonna wrap them up in my little web. But I'm not going to do it in a way that's going to offend other people. I'm not going to be disrespectful to the witness, even if they're disrespecting me. I know how to comport myself.
Right. I mean, no, a lot of people think, oh, I want the Tom Cruise, Jack Nicholson, view of you can't handle the truth, and judges hate it too. Oh, judges hate. I've never had a judge that I have seen where someone got aggressive and they look at it kindly. Ever, not once. How about you?
Really not with the judge. I mean, maybe with the witness, and if there's a reason to do it, but just to do it, it's not going to work.
Some people come out of the gates like that, and you're like, why are you screaming? Why are we screaming here? It's not the time to scream.
I always say choose your battles.
Absolutely. Well, you also, aside from, capital murder, you also mentioned to me that you have defended some very, maybe celebrity status or sports status clients that end up with some criminal issues sometimes. Tell us more about that.
Yes, they're human beings too, believe it or not.
Absolutely.
And I've always been very close to to mixed martial arts and boxing. In fact, I don't know if I've told you this, Reggie, but I have my law office behind it. I own a huge boxing gym.
Oh, cool.
Yeah, I'd love to show. Maybe I can bring the
Yeah, we'd love to see it. Yeah, yeah.
Okay, you're gonna.
All right, so we have a fun exclusive. Daniel Martinez is taking us to his boxing studio that is in the back of his law practice. And Daniel, this is the coolest place ever. Show us around.
This would be the other side of my office. So this is the front where the business happens, if you will.
Yes.
And I have a boxing gym with a full size ring. We've got 3 speed bags. We have some exercise equipment. Of course, I have some promotional stuff, flags on the wall. Every boxing gym's got to have the flags.
You have to, yes.
And
so cool.
I give out promotional shirts for the athletes that come in, and we have three of these. These are called double end bags, full size mirrors.
I love it.
Heavy bags, and this is a squat rack.
Very cool.
We were talking about pro athletes. This is George Masvidal, game-bred fighting championships. He's one of the most famous UFC fighters, and I've helped him with some matters before. Actually, not criminal, so that's why I say it.
Right. Very cool. Very cool. This is so neat to be able to see like an actual like live tour. And you mentioned too that you also help coach Special Olympics. Tell us how you got involved in that.
I sure will. And one of my really good friends, we call him Coach Joe, Joe Luther. And I met him, I want to say 8 or 9 months ago when I was first opening my gym. And it was serendipitous because he runs the Special Olympics program out of Brevard County. And he said that he was having trouble with his construction of his gym and that they were going to be delayed about 6 months. So I said, how about this? Why don't you bring the kids here and train? I'm not going to charge you anything. In fact, I don't charge anybody for the training. That's
so cool.
My service to the community.
I love that.
And it helps my clients that are young and impressionable that don't have good role models.
Right.
Gives them a place. But so anyway, the Special Olympics kids have been coming here,
so cool,
training with us. And now we have a thing where it's like, side note, we do a movie once a month. I rent out a movie theater in Palm Bay or West Melbourne, which is about 15 minutes away. And we take the special needs, well, basically anybody, we're all inclusive,
right?
But very heavy leaning towards the Special Olympics.
That's so cool. That is so neat. I love that. And I love that you give back to the community and you've got business in the front, party and boxing in the back. I love it. It's so cool. Well, Daniel, it's been great talking to you. I would love for you to give maybe some advice as a seasoned, trial attorney to anyone starting out there who is, going into litigation, especially how to connect with juries and with a judge. What is your advice here as someone who's done that for several years?
Sure. Know your audience first and foremost. What works for one person is not going to work for another person. Do not have a all size fits all approach. Carefully consider all the facts of your case. Be confident in yourself. It comes with time. So you're not going to initially have to be in your comfort zone, but
right.
Have a mentor, somebody you can talk to and ask questions. Certainly don't learn from TV lawyers.
No, that's great advice.
And remember that sometimes less is more.
Right.
Sometimes the best defense will be quieter than the loudest defense.
Absolutely. I think there's such wisdom in that. And I think that's also true with like rebuttal. Sometimes I think there's power in not rebutting. If you've already made the statement and it's perfect, don't touch it again. Don't touch it.
Totally agree. And a few things give me more pleasure than not having to cross-examine a witness. When I'm almost like saying the other side didn't do their job, I'm dropping the mic.
Yeah, you're like, no more questions for this witness.
I don't even need to cross this witness. They didn't touch me.
I agree. It is like a proverbial like mic drop. You're like, I don't need no I love it. Well, Daniel, it was great talking to you and joining us for lawyer interviews. Thank you so much and giving us a tour of everything. Please let our viewers know too where they can find you on social media if they'd like to connect.
Sure. On Instagram, I am the Fight Lawyer, THE Fight Lawyer. And again, that's from me being heavily involved in the UFC and boxing. Mm-hmm. On Facebook, you can find me at Daniel Martinez or the law offices of Daniel Martinez, PLLC. On Twitter, I'm Baby I Like It Law.
Okay.
And I think that's it.
Awesome. Well, thank you again for joining us today. And thank you everyone for watching Lawyer Interviews. We'll see you next time.
Have a great day. Thank you for having us.
Again, thank you all for watching Lawyer Interviews. And again, thank you for Mr. Martinez and today's Lawyer Interview sponsor, Litigation and Select America's Legal Elite in Media. Connect with Litigation for custom, innovative, and disruptive branding solutions to accelerate lawyer, law firm authority, grow six-figure practices, and aid access to justice.